constitutional issues do not arise for the consideration of the learned magistrate. The application is frivolous and vexatious because, first of all, there are no real constitutional issues, and they certainly do not arise for consideration at this time. First, because many of these rights which they rely on expressly exclude extradition from consideration, and also because the magistrate has a certain duty to perform, and the duty that she has to perform does not include the considerations that the defendants have raised. The defendants raise an issue which would not normally have arisen in extradition proceedings before the magistrate. In fact, they raise it to the press and not to the court. And so we heard about it, and so we were able to provide a diplomatic note which dealt with that issue. It's an issue that lawyers call specialty, which is that the defendants will not be sent to a third state from the requesting state.
Well, the arguments today centered around the unconstitutionality of the amendments made in 2009. We believe that we would have presented the arguments clearly, which shows their potential unconstitutionality and the basis for the referral to the High Court. We would have dealt with the principles applicable for referral, that it must not be frivolous and vexatious. We articulated the reasons why it's not frivolous and vexatious, to have the questions that we wanted to refer to the High Court be determined by the High Court. The learned friends on the other side would have made their arguments. We would have only learned and heard of them today. We sought to get and obtain from the court an opportunity to put in written submissions, which she granted. We have until tomorrow morning to respond to their oral and written submissions and to lay it over with the court. The new disclosure made today is in fact part of the very problem that we have with the proceedings. Firstly, we've been trying on each and every occasion, and you would have heard me say so in court, to have complete disclosure before we respond to whatever is brought in the court and before we make our submissions. Once again, that did not happen. But more importantly, this disclosure seeks to remedy the very breach of the legislation. They seek to produce a document from the United States which sought to give assurances in relation to the non-re-extradition. The full court would have ruled that in relation to any such thing, it must be in the treaty. So we are of the view that currently that document has no legal validity.